Welcome to this review of motions under the 2019 Amendments to the Rules of Civil Procedure. Today, we're cutting straight to the chase, focusing on what you need to master for the bar. We'll cover the fundamental concepts of litigious versus non-litigious motions, their formal requirements, prohibited motions, and specifically, the rules on dismissal of actions. These areas are perennial bar favorites, packed with examiner traps. Our goal is not just to define, but to understand the practical application and key distinctions that differentiate a passing answer from a mere recitation of the rule. You are already expected to know the basics. We are here to get you to chair-level depth. First, let's nail down the essential definition of a motion. Rule 15, Section 1 defines a motion as an application for relief other than by a pleading. So remember, a motion is anything that asks the court for something, so long as it isn't a pleading, like a complaint or an answer. This clear distinction is critical for your analysis. And here's a fundamental principle. Section 2 states all motions must be in writing. This is the general rule, the default. You write them down. However, there are two crucial exceptions. First, motions made in open court. Second, motions made in the course of a hearing or trial. When these exceptions apply, the motion is oral, not written. Bar trap alert. Don't get fooled by a problem that says the defendant filed a written motion for continuance 1 minute before the trial started. That is not an exception. It's a written motion. The exceptions apply to motions made orally in the court's presence during a proceeding. They are not written motions. The rule also has a specific requirement for these oral motions. The court must immediately resolve them, and it must give the adverse party an opportunity to argue their opposition. This opportunity to oppose is a due process guarantee. It's a bar exam phrase you can lift. The adverse party must be given the opportunity to argue his or her opposition thereto. Take a moment to absorb this. Written motions are the norm. Oral motions are the exception, and they come with a non-negotiable procedure. Getting this right is a quick point. Now, let's dive into the most significant structural change in the 2019 rules: the formal segregation of motions into non-litigious and litigious categories. This distinction isn't just academic, it dictates the entire process. Section 4 defines non-litigious motions as those the court may act upon without prejudicing the rights of the adverse parties. The critical procedural consequence is that these motions shall not be set for hearing and shall be resolved within 5 calendar days. You can lift this. Shall not be set for hearing and shall be resolved within 5 calendar days from receipt. This is a non-negotiable timeline for the court. Let's look at the examples provided in the rule, as they are your guide. Motion for extension to file an answer. Motion for postponement. Motion for issuance of a writ of execution. These are routine administrative motions. Granting them doesn't take away anyone's rights. Now, let's contrast this with litigious motions, defined in Section 5. These are motions which raise issues that are contentious and adverse, and therefore could prejudice the rights of the opposing party. The list in the rule is the definitive guide. Motions to dismiss, for new trial, for reconsideration, for summary judgment. These all seek to end the case or change its outcome, directly affecting the other party's interests. That's the hallmark of a litigious motion. The procedure is completely different. Litigious motions require opposition from the adverse party within 5 calendar days from receipt. No opposition, no problem. The court resolves it. If there is an opposition, the court has 15 calendar days from receipt of that opposition to resolve the motion. The court also has the discretion to call a hearing if it deems it necessary. This distinction is paramount. For the bar, you must be able to classify a given motion as either litigious or non-litigious, as this determines the entire procedure. A wrong classification means a wrong procedural step, which will cost you points. Now, let's talk about the dreaded prohibited motions. These are the landmines of civil procedure, and you must memorize them. Section 12 of Rule 15 is your no-fly zone. It starts by prohibiting motions to dismiss, except on 3 specific non-waivable grounds: lack of subject matter jurisdiction, latus pendentia, and res judicata or prescription. Any other ground for dismissal that was once allowed, such as failure to state a cause of action, is now treated as an affirmative defense in the answer. This is a monumental shift. You cannot file a motion to dismiss for failure to state a cause of action. That is a prohibited motion. Understand the logic. The new rules want to avoid early dismissals on grounds other than those that fundamentally deny the court's power or prevent the refiling of the same case. They want the case to proceed to the next stage, the answer, where all non-jurisdictional grounds for dismissal are raised. Other prohibited motions include the motion to hear affirmative defenses, because affirmative defenses are taken up during pretrial, and motions for reconsideration of the court's action on those affirmative defenses. Two other common traps are motions to suspend proceedings without a higher court order, and motions for extension of time to file pleadings other than the answer. The rule explicitly states that motions for extension of time to file pleadings are generally prohibited, except for the motion for extension to file an answer. Be careful with this distinction. Finally, we have motions for postponement intended for delay. The rule is very strict on this. They are prohibited, unless based on an act of God, force majeure, or physical inability of a witness to appear and testify. Even then, you must pay a postponement fee, and the court must warn you that your evidence presentation must still be completed on the remaining dates. This is a clear move to prevent dilatory tactics. So, to recap the prohibited motions. 1. Most motions to dismiss are out. Only the big three are in. 2. No motion to hear affirmative defenses. 3. No motions for extension of time for pleadings other than the answer. 4. Postponements are severely restricted. Memorize this list. It is pure exam gold. Let's pivot to Rule 17, Dismissal of Actions. This rule governs when and how a case is dismissed, whether by the plaintiff, the defendant, or the court. It's often tested in conjunction with Rule 15. First, dismissal upon notice by the plaintiff. This is a voluntary, unilateral act of dismissal. The plaintiff can do this by filing a notice of dismissal at any time before the service of the answer or a motion for summary judgment. The key here is the timing. It's a race between the plaintiff's notice and the defendant's responsive pleading. If the notice is filed first, it's typically without prejudice, meaning the plaintiff can refile the case later. But there's a critical two-dismissal rule exception. If the plaintiff has already dismissed the same case once before in a competent court, the second dismissal of that case by notice operates as an adjudication upon the merits. This means it is with prejudice and bars refiling. This prevents serial filing and dismissing. Next, dismissal upon motion of the plaintiff. If the timing for the notice of dismissal has passed, the plaintiff must now ask the court for approval to dismiss. This is no longer unilateral. This situation most commonly arises when the defendant has already filed a counterclaim. The court will approve the dismissal of the complaint, but it is typically limited to the complaint. The defendant's counterclaim is not dismissed. The rule gives the defendant a choice. Within 15 calendar days, they can manifest their preference to have their counterclaim resolved in the same action or prosecuted in a separate action. This is a bar exam favorite. The plaintiff cannot force the dismissal of a counterclaim that has already been filed. Our final topic under Rule 17 is involuntary dismissal, and the most important category is dismissal due to the plaintiff's fault. Section 3 covers situations where the plaintiff themselves is to blame. This can happen if, for no justifiable cause, the plaintiff fails to appear at the presentation of their evidence, or to prosecute their action for an unreasonable length of time, or to comply with the rules or a court order. The key here is the no justifiable cause. If the plaintiff's failure is excused, the action should not be dismissed. But if it's pure negligence or dilatory intent, dismissal is appropriate. This type of dismissal can be initiated by a motion from the defendant or by the court motu proprio, meaning on its own initiative. The effect of this dismissal is critical. Unlike the notice dismissal or the motion dismissal in Section 2, a dismissal under Section 3 generally operates as an adjudication upon the merits, which means it is with prejudice and bars a new action on the same claim, unless the court provides otherwise in its order. So, Section 3 is punitive. The plaintiff was at fault, so they lose their right to refile. It is a bar exam phrase to commit to memory. Adjudication upon the merits unless otherwise declared by the court. Again, If a counterclaim was pleaded by the defendant before being served with the dismissal motion, it is not dismissed. The defendant can still choose to prosecute it in the same action or a separate one, just as in Section 2. The plaintiff's fault does not take away the defendant's right to pursue their claim. Let's bring it all together with a bar exam-style scenario to test your understanding. Here's the problem. A. Inc. sues BComE to collect on a promissory note. In its answer, BCom includes a permissive counterclaim for damages based on an unrelated breach of contract. Before the pretrial, A. Inc. files a motion to dismiss its own complaint, alleging financial difficulty in prosecuting the case. The question is twofold. Can A. Inc. dismiss its complaint, and what happens to BCom's counterclaim? Take a moment to think about it using the rules we just discussed. Let's analyze. A. Inc. filed a motion. This means we're dealing with Rule 17, Section 2, not Section 1. Why? Because the answer with the counterclaim was already served. The time for unilateral dismissal by notice has passed. So, the court can approve the dismissal of A. Inc.'s complaint, but it is not automatic. The court has discretion. Based on the facts, there's no reason to deny it, so we can assume the court will approve. Now for the counterclaim. Because the counterclaim was filed prior to the service of A. Inc.'s motion to dismiss, Rule 17, Section 2 dictates that the dismissal of the complaint is limited to the complaint. It does not affect BCom's counterclaim. BCom now has 15 calendar days from notice of the motion to decide. It can manifest its preference to have its counterclaim resolved in the same action, or it can prosecute it in a separate action. The choice is entirely BCom's. Let's refine our understanding with another key bar trap. Rule 15, Section 13, on dismissal with prejudice. This section clarifies when a dismissal has the effect of an adjudication upon the merits, meaning it's with prejudice and bars refiling. This rule is a companion to both Rule 15 on motions to dismiss and Rule 17 on dismissal of actions. The rule lists specific grounds for dismissal that are always with prejudice. These are the bar's favorite grounds for dismissal because of their finality. First, dismissal based on res judicata or prescription. Second, dismissal based on payment, waiver, abandonment, or extinguishment of the claim. Third, dismissal because the claim is unenforceable under the statute of frauds. These three grounds are automatically with prejudice. Notice what's missing from this list. Lack of subject matter jurisdiction is not listed. Neither is litis pendentia. That's a crucial distinction. A dismissal for lack of jurisdiction is without prejudice. The court is merely saying it lacks the power to hear the case, not that the case itself is without merit. The plaintiff is free to refile in a court that does have jurisdiction. The same logic applies to litis pendentia. The court is dismissing because the same case is pending elsewhere, not because of its lack of merit. It's a procedural dismissal, not a substantive one. So, remember, jurisdiction and litis pendentia are the big exceptions. All others in Section 13 are with prejudice. Let's quickly review another important concept that is a regular bar topic, the omnibus motion rule. Section 9 of Rule 15 states that a motion attacking a pleading, order, judgment, or proceeding shall include all objections then available. The critical phrase is all objections not so included shall be deemed waived. This rule prevents a party from filing multiple successive motions raising different grounds one after another, which would unduly delay the proceedings. It forces you to put all your eggs in one basket, so to speak. There are three sacred, non-waivable exceptions to this rule. These are the same three grounds on which a prohibited motion to dismiss can be filed. Failure to raise these objections in an omnibus motion does not result in waiver. This is another example of the internal logic of the rules. The grounds for prohibited motions to dismiss are also the grounds that can never be waived. This makes perfect sense, as they deal with the fundamental authority of the court and the finality of litigation. So, remember, file one motion, raise all the objections you can, or risk losing them forever, unless you're talking about jurisdiction, litis pendentia, or res judicata or prescription. Let's summarize the key takeaways from our review of motions. First, always determine if a motion is written or oral, litigious or non-litigious, as this dictates the proper procedure. Second, Be vigilant for prohibited motions, especially motions to dismiss on grounds other than jurisdiction, litis pendentia, or res judicata prescription. Any motion to dismiss for failure to state a cause of action is a prohibited motion. Third, understand the distinctions in dismissals. A unilateral notice of dismissal can be with or without prejudice due to the two-dismissal rule. A dismissal on motion allows the defendant to protect their counterclaim, and a dismissal due to the plaintiff's fault is generally with prejudice. Finally, remember that lack of subject matter jurisdiction is never waived and never results in a dismissal with prejudice. This is a golden rule of civil procedure. By mastering these concepts and their practical applications, you'll be well prepared to tackle any question on motions and dismissals. Focus on the why behind the rules, and you'll be able to navigate the bar exam's procedural twists and turns. That's it for this session. Good luck with your review.